question. It's been a long time since I've been called a boy. I think that's fair to say. No, by my colleague who suggested that you tended to pick us, Mr. Chairman. Mr. Chairman, I want to talk in particular about the amendment which provides the exclusion for these organisations, these partnership schools, from the Official Information Act. Mr. Chairman, I want to explain to members, because from my colleague Megan Woods, I understand that the Select Committee could well have been misled by officials as to the workings of the Official Information Act. It's an area with which I, as a minister, was quite familiar and have had discussions subsequent to being a minister on the application of the Act with Dave McGee and with Beverly Wakeham. The point that I do want to make is that where there is a contractual arrangement, for example, with an independent school or with an early childhood centre, which is not any early childhood centre, and the money is flowing from the government to that organisation as a result of that, it means, Mr. Chairman, what it means is that the information that shows that the organisation is fulfilling its end of the contract is subject to the Official Information Act, notwithstanding the fact that that organisation is not a state organisation or a local authority in its own right. And so it is a matter of the ability to track that. And the question I have, which is a relatively simple question for the Minister, is why should the information which sits within the private schools in my electorate, or the independent schools as they prefer to be called, why should the information that is sitting in those schools and is available to the government, because it is something which follows the contractual arrangements, and it's something which the Ombudsman has made clear is available to members of the public using that Act, and especially to parents using that Act. They have the right to that information if it's an independent school. How can it be right that we are doing within Clause 52 of this bill an amendment, which I sort of hate to use the parallel, makes it the same as the parliamentary service, and the door doesn't get open at all? Now, that is the effect, that is the absolute effect of this. It puts us with, I don't know anything about mortality review committees.
Sounds pretty scary.
Well, it does. It does. And there could well be some good reasons for that information. I know it's arguable that there are good reasons for the parliamentary service as well, for some aspects of it. But, Mr. Chairman, I cannot see an argument which makes it right that information which is available as a result of a contractual arrangement with an independent school should not be available as a result of a contractual amendment, of the same sort of contractual arrangement with one of these partnership schools. And that is the effect of Clause 42. I mean, I'm going to be really interested in the Minister's response to this, because it is. I mean, I know it's a fine point of law, and it's a point of law that's only really been tested by the Ombudsman in in this particular case, his application as to the Official Information Act. But it is important, because one of the things that I think is vital is that parents, accepting with a heavy heart that we're going to end up with this sort of school, I think the parents of that school should not have lesser rights to get information from that school than the parents of the state schools. Mr. Chairman. Mr. Chairman.
Honourable Hekia Parata.
Mr. Chair, thank you. I'd like to take a call on the theme of transparency